Hi, I'm Paul Trudelle.
And I'm Doreen So.
And you're listening to Hull on Estates, and this is episode number 527. How are you today, Doreen?
How are you? I'm good, thanks.
Great, thanks. So today we thought we would talk about a very recent case of the Ontario Court of Appeal, the decision of Bruff-Murphy and Gunawardena, which was released on June 16, 2017, and it deals primarily with the issue of expert witnesses and their role in the litigation process and the role of the judge in regulating the expert witnesses that testify before the trier of fact.
Right.
So maybe we can just give a bit of background about the case that led to this appeal.
Sure. So this is a case that came about because of a car accident, shall I say.
Yep.
Bruff-Murphy was the person who was hit by the defendant, Gunawardena. The fact that Gunawardena hit Bruff-Murphy is not an issue before the trial judge. The issue before the trial judge was damages, and they actually had a 23-day jury trial on the damages that Bruff-Murphy claimed. Now, she was claiming that she suffered multiple physical and mental injuries as a result of the accident, and a number of witnesses were called, many psychiatrists and other medical expert witnesses, but this decision really focuses on one psychiatrist in particular.
Right. And this was the defense medical that the plaintiff was subjected to, and that defense medical psychiatrist gave an expert opinion and testified at trial.
Right.
And that was what underlies the appeal here. And just to get back to the case, though, the matter went on for 23 days. There was a jury trial. At the end of the 23 days, the jury awarded damages to the plaintiff, but only in the amount of approximately $23,000, $23,500.
Yeah.
So the damages were minimal after such a lengthy trial. At the end of the trial, or during the trial, the insurer, the defendant, brought a motion for a declaration that the plaintiff didn't meet the threshold required in order to bring the claim. The judge ruled on that separately from the jury's assessment of damages and found that the plaintiff did meet the threshold. The judge's comments with respect to the defense expert in that decision were highly critical of the defense expert and felt that the defense expert went too far, partisan, fell into the fray, and wasn't fair and objective in his role as an expert. So the appeal was with respect to the jury finding and whether the judge erred in allowing the expert evidence or not taking steps to rein in or temper the partisan nature of the defense expert's evidence. The Court of Appeal starts by saying that the law regarding expert witnesses has evolved considerably over the past 20 years. In particular, there's reference to the rules of civil procedure that state that an expert is to be fair and objective and non-partisan. And so that was recognized by the Court of Appeal, and there's a number of cases that stand for that proposition. So the experts have to be neutral, non-partisan, and give objective evidence. The Court of Appeal also comments that the role of the trial judge has also evolved over the years in order to make sure that the expert evidence and the expert's duty of neutrality is preserved. And the court goes to great lengths to discuss what a trial judge's role is with respect to expert evidence.
Right. The Court of Appeal described the trial judge's role as that of a gatekeeper, and that the gatekeeper function lasts throughout the evidence of the expert. It's not just a matter of when the expert is tendered as trial as an expert witness, that initial motion where the witness is qualified in his or her area of expertise, questions get asked as to like the scope of his or her opinion, and at that stage it is still up to the trial judge to say you are admitted as an expert witness in this particular area, and then you can give evidence. But the Court of Appeal is saying that gatekeeper function doesn't stop after that initial admissibility motion. It continues throughout, so that when you actually start to hear the entire breadth of this expert's evidence, at any point it seems like there's more prejudice than there is probative value to this person's evidence. The Court of Appeal is saying there are many ways that should be handled in a way that it doesn't cause irreparable harm to the trial outcome.
Right, and I think that was where they found the trial judge in this case erred. The trial judge considered the qualifications of the expert and qualified the expert as an expert in being able to give testimony, and then appears to just have stepped back and felt that their job as gatekeeper was over at that initial stage,
Right.
whereas the Court of Appeal cautions that it's the obligation of the trial or trier of fact to keep that guard up with respect to evidence going too far or crossing the line into partisan territory.
Right.
I think that we should maybe talk a bit about why the expert evidence crossed the line in this
Right.
case and what the concerns were, and then maybe we can talk a bit about what a trial judge can do if during the course of the trial it appears that the expert is becoming partisan.
Right. So a big issue with the Court of Appeal was the actual methodology of this particular expert. Now, this expert is a psychiatrist, and they were asked to give a psychiatric opinion on the plaintiff's condition and her complaints and whether or not that actually matches, and that's the case that she has to prove. And because he's a defendant's witness, his process, according to him, was that he meets with the plaintiff first, have a verbal interview with her, and then he goes about and reviews her medical records. And his practice is entirely focused on considering whether or not the interview that occurred before reviewing the records is consistent with the information in the records. But what he doesn't do after, realizing that there may be, like, say, 10 inconsistencies, he doesn't go back and ask the plaintiff to explain why that may have been the case.
Right, and I think that in this case the expert report spent a great deal of time talking about the inconsistencies between what the plaintiff said during the interview and what the medical record said, and didn't spend a lot of time on her psychiatric condition. And the fact that the plaintiff didn't have a chance to respond or explain the inconsistencies, the Court of Appeal felt that that was unfair.
Right.
And wasn't productive in the circumstances.
Right.
Now, there was one of the grounds for appeal was that the plaintiff wasn't given her Brown and Dunn rights, meaning that if there's evidence to be led that is contrary to what she is saying, it should be put to her so that she can explain that. I don't know how that would apply in the context of an expert report here, but although Brown and Dunn may not strictly apply, the underlying principle of fairness,
Right.
I think, does apply, and the Court of Appeal seemed to suggest that it did apply and that the expert should have asked her for clarification
Right.
or an explanation. And in this case, the plaintiff didn't have a chance to explain the inconsistencies with respect to the expert evidence.
Right.
The Court of Appeal talked a bit about what a judge could do in the circumstances where it appears that an expert witness is going too far. But first there's the qualifying stage where you qualify the expert, and there's the test set out there as to when an expert will be qualified to give expert testimony, and the judge has to be very careful there to balance the prejudice versus the probative value of the evidence. Once that threshold has been overcome, the trial judge has to maintain the gatekeeper role and make sure that the evidence doesn't go too far or doesn't become partisan. And the Court of Appeal talks about some of the remedies that a judge or recourse that a judge could have, such as cautioning the witness, such as limiting examinations to certain topics, a charge to the jury at the end of a trial or mid-trial when the expert is testifying may be appropriate. The judge should also consider a mistrial in the event that the evidence is so prejudicial it can't be cured by a charge or a warning to the jury.
Right. Yeah, I talked about sort of maybe instances where there may be appropriate pauses that could be taken where the jury is sent out of the room, submissions are sought from counsel, and then have an actual voir dire outside of the jury's knowledge in order to deal with some of these issues, or if it's something that really does have to be, testimonies being given, you really do have to stop it like midway because it is truly so prejudicial to still actually go about doing so.
Right.
Because that is just how important that gatekeeper function.
In this case, the defendant argued that the expert was just one of many witnesses and it may not have had a significant effect on the jury's deliberations.
Right.
However, the Court of Appeal disagreed and said that they had no way of knowing what the effect of that expert was on the jury's deliberations. So
Right.
the remedy they came up with was to order a new trial. It's back to trial for them, and either with the same witness with some sort of caution or with other experts perhaps. I think the cautionary tale that I take away from this is just be very clear with your expert witness as to the nature of the evidence that they give.
Right.
Ensure that it's fair and objective, and they honor their undertaking to be fair and objective, and just not to let your expert fall into the fray or become a partisan witness.
Because otherwise that will just have a lot of wasted costs for both you and your client.
Right.
Whereas, you know, as lawyers you can always tell the expert, actually, perhaps you could do X, Y, and Z more just to handle the issues of fairness, like you say.
Right, right. And also discuss the methodology with the expert so that you know
Right.
beforehand what their methodology is and whether that is going to raise any red flags or alarm bells once it gets before a judge who is to be fulfilling this gatekeeper role.
Right.
Well, it's a very informative case on the issue of expert evidence. We'll put the link up to the case on our
That's right.
blog
That's right.
and posting. And until next time, I want to thank you for listening. Thank you, Doreen.
Thank you.
And if you have any questions, please email us at webmaster@hollandhall.com or leave us a comment on our blog. Thank you for watching.
Thank you.